and the success of identifying the two who are responsible for it in such a short period of time is attributable to that work of state and local law enforcement, but also contributed to by us and the relationships.
Thank you very much, Senator Grassley, and I apologize, Senator Grassley, taking extra time on this. Please go ahead.
I just told him he doesn't need to apologize. He's chairman of the committee. During the last hearing, May 2012, Senator Hatch asked a question as whether or not President Obama discussed potential successors with you. You responded at that time that he had not in the past, or had in the past, but not recently. Now, I don't expect to get any information on the content of a discussion you might have with the president, but I do ask this question. Since the hearing May 2012, have you discussed potential successors with President Obama?
Well, yes. I generally don't like to get into conversations between myself and them, but I will say yes without any context.
You've answered the question.
Okay.
Do you have a transition plan in place for your successor, and if so, how much time is needed to implement the plan in order to provide a seamless transition?
We've been preparing, as you can imagine, for the last 2 years. In fact, the last 2.5 years. And we have already prepared the extensive materials that the successor will have to review. We're prepared to start the briefings as soon as the person is sworn in. We have been looking at personnel so that there can be some overlap of personnel so that the person comes in and has key components that are ready to support them. In the same way that when I came in before September 11th, the FBI supported me.
Approximately how much time is necessary for that?
Well, it is a learning experience, and we'll get the briefings and the like, but it will take maybe I would say a month to really get one's feet on the ground. But in that month, I can tell you something's going to happen. So whatever you planned in terms of sitting down and looking at something else will come up and your attention will be diverted. So it's hard to say a specific time frame.
This is so important because we'll have about 4 weeks in July. We'll have only 4 days after your term ends to consider a nominee. Do you have any idea when we might expect a nominee to come up from the White House?
I do, but I'm not in a position to be able to advise the committee.
Then let me go on to another one. This involves Fast and Furious. In my opening statement, I said I know that the FBI doesn't talk about ongoing investigations. However, eventually, the FBI has to talk about the Brian Terry murder investigation, just like eventually you had to talk about the anthrax investigation. I'm going to be submitting a detailed list of questions about the concern that the Terry family has that there was an attempt to cover up the connection between the guns and the ATF operation. According to the family, the indications of an attempted cover-up haven't been fully investigated. So all I'm asking you now, would you be able to respond to my written questions before you leave office?
I would have to look at it and see how extensive, but we'll make every effort to do so.
Okay. And then just one question in regard to this issue. So I'll ask right now. On October the 20th, 2011, I wrote you to ask what time the FBI arrived in Peck Canyon, where Border Patrol agent Brian Terry was murdered. There are conspiracy theories out there that the FBI or an FBI informant was out in Peck Canyon before Agent Terry was shot. Do you believe that there's any truth to those theories?
No, I don't believe there's any truth in those theories, but I would have to go back and make certain. Off the top of my head, I don't believe there's any truth, but I'd like to go back and make certain that we have nothing that would be supportive of those theories.
Okay, and then I would like to have that in writing. I want to go to drones. In recent responses to questions I asked Attorney General Holder following his last oversight hearing, the Department of Justice advised this committee that both DEA and ATF have acquired unmanned aircraft systems. The department indicated that those agencies were drawing up plans and procedures to use them. The responses did not indicate whether the FBI had acquired any drones, and whether there were future plans for drone technology used by your agency. Does the FBI own or currently use drones, and if so, for what purpose?
Yes, and for surveillance.
Okay. Does the FBI have any agreement with any other government agencies? Let me suggest a couple. There might be others. DOD and Homeland Security to receive assistance in the use of drones.
I'm not certain. I don't think so, but whenever, well, all I'm saying is that one of the issues with drones, by any use of drones by any agency, is what happens in the airspace. So to the extent that it relates to the airspace, there would be some communication back and forth.
So instead of asking a question, I think I can assume, since you do use drones, that the FBI has developed a set of policies, procedures, and operational limits on the use of drones, and whether or not any privacy impact on American citizens.
Well, we are in the initial stages of doing that, and I will tell you that our footprint is very small. We have very few and of limited use, and we're exploring not only the use but also the necessary guidelines for that use.
Does the FBI use drones for surveillance on U.S. soil?
Yes.
I want to go on to a question.
And well, let me just put it in context, though, in
Sure.
a very, very minimal way, and very seldom.
Okay. Currently, it is a crime to purchase material for the production of illegal passports, to forge illegal passports, to distribute illegal passports, and to engage in other criminal activity that facilitates trafficking of false passports. The immigration bill before the Senate will weaken this current law. Under the bill, only those who produce, issue, or distribute 3 or more passports will have committed a crime. Under the bill, only those who forge, alter, or possess or use 3 or more passports will have committed a crime. Even more outrageous under the bill, only those who use any official material to make 10 or more passports will have committed a crime. Question: will these changes in current law have a negative impact on counterterrorism or counterintelligence efforts of the FBI?
I'm not familiar with the current law, and even less so with the proposed law, so I would have to get back to you on that particular question.
It would be very important that you get back to us in 2 or 3 days, because these are issues before Congress right now.
I'll try to, but I must say I'm not certain we have that much experience in the prosecution under those statutes. But let me look at it, and I'll try to get back to you in short order.
Would you agree with this, that the weakening of current law creates a loophole that could allow terrorist groups such as Al-Qaeda or Hezbollah or other foreign spies to more easily operate within the United States?
Without analyzing the bill, I really am not in a position to opine on it.
Okay, I will yield.
Senator Lee.
Thank you, Mr. Chairman, and thank you, Director Mueller, for joining us today and for your service to our country. With respect to Section 215 of the Patriot Act, is it the Bureau's practice to request records or other tangible things related to Americans that themselves are not relevant to an investigation, to obtain foreign intelligence information or to protect against international terrorism or clandestine intelligence activities?
I'm not certain I understand the question. Are you talking
so when you
about
make
215? I mean, we're the applicants on 215 orders. But,
I understand. You're the applicants, and when you make the application, is it your practice to request things that themselves aren't relevant to the investigation? In other words, do you confine your requests to those things that are related to an investigation, or are they broader than that?
Well, in the 215 context, the application to the court and the court's finding defines relevance in that particular context. And as we've talked about and have been discussed the last 2 weeks, And so I would have to direct you to the orders and I know that they're not published, but the fact that the FISA court has ruled that the gathering of the metadata satisfies the relevance definition within the FISA statute.
Right, right. And so under that, with that understanding, that you necessarily do cover a lot of data that is itself not closely tied to an investigation, you can understand why a lot of people would be concerned and why they'd also have additional concerns about the fact that we've got not only secret data gathering activities going on, but also that they're undertaken pursuant to secret law, secret orders that the American people can't have access to. But if as we've been told, it's necessary for the government to collect and store really vast quantities of information, including information on Americans that is itself unrelated to foreign intelligence or terrorism investigations, then,
if I may, are you talking about the metadata?
Yes.
The telephone numbers. But I want to make certain we're talking about that, not content.
Yes, for now we're talking about the metadata. Okay. Then a lot of people have concerns about what, if any, limiting principles there are that would prevent the government from ultimately storing all information about all Americans. Meaning just collecting more and more of this metadata and holding it for very long periods of time or perhaps at some point in perpetuity. Does the Department of Justice or does the FBI have a view on the constitutionality of gathering information on Americans and storing it so long as it doesn't perform queries on that information?
I think I understand the broader question. I would say that the Justice Department believes that the program in place, 215 program that has been upheld by the FISA court, is certainly constitutional. I would limit it to that set of facts because they're a discrete set of facts that with the attendant protections on privacy that I think the Department of Justice as well as the FISA court believe absolutely it's constitutional.
And at some point, do you sympathize with those who would say, even if this is metadata, the fact that you can collect that quantity of metadata, store it for a long period of time, and the fact that it can later be searched brings about a certain intrusion on privacy, even if it's a privacy intrusion perhaps not cognizable in court?
Well, and as you well know better than most, in Smith versus Maryland, it's not protected by the Fourth Amendment. So yes, sir, without a question of doubt, privacy concerns, but I would say they're de minimis privacy concerns compared to just about every other intrusion as you get more predication in an investigation. In fact, it's at the bottom level. Yes, do I think that it would be concerning to people to know that there's a database? Yeah, absolutely, which is why I do believe that it's important that this is upheld by not just the Department of Justice, not necessarily just by the Inspectors General, but also by the FISA Court and Congress.
Okay. And, you know, I think it's important to remember also that the precedent you cited is, of course, decades old, and it didn't deal with the sheer volume of metadata that we're now talking about. The technologies that are at issue now didn't exist then, certainly weren't even contemplated then. And the more you aggregate large quantities of metadata, potentially on every single American citizen, and you give someone within the executive branch of government the power to search all of that, you do give them a pretty broad view into the lives of the American people. The more data you get, the more you add to that metadata, even if any one of those data points might be itself constitutionally insignificant. Don't you think you start to approximate a point at which you start to breach a reasonable expectation of privacy?
I certainly believe there quite probably is a scale, yes. But it was the same dialogue we had 20, 30 years ago about telephone toll records, which triggered the Smith versus Maryland case. And it is the same debate, albeit with metadata as opposed to telephone toll records, but you have pretty much the same piece of data in both cases. So I would argue that Smith, even though it's not exactly the same as a telephone toll record, the proposition that was espoused by the Supreme Court and Smith versus Maryland is applicable today.
Did we have the
comparable data? Let me just put it that way.
Right. Did we have the capacity to gather, analyze, and store in perpetuity that kind of metadata on every single American citizen at that point?
It would have been tremendously burdensome to do so at that point. You could do it, but it would be wholly ineffective. One of the differences today compared to 20 years ago is it was in the telephone company's interest to maintain telephone toll data because their billing was based on telephone toll data. Today, that is no longer the case. In fact, the telephone companies see it as a burden, a storage burden, and consequently, that information that was there in the telephone companies 20 years ago may well not be there today, absent 215.
Okay. And thank you very much, Director Mueller. I see my time has expired. Thank you. And thank you, Mr. Chairman.